Hi everyone. Um, I'm not sure that I'm going to get many people tonight, but this is the only time I can do it. So I want to discuss a case that was in the Massachusetts Supreme Court. It started in district court, and then, spoiler alert, the Massachusetts Supreme Court denied the man the right to die. Um, I'm going to get started by reviewing the procedural history of the case. So here's the excuse me. So here's the district court case. Robert Kegler, a retired physician in Falmouth, Massachusetts, has lived with prostate cancer for 2 decades. As a doctor himself, Roger dealt firsthand with cancer his entire professional life. Although his current cancer treatments have been working, he knows exactly how devastating its various symptoms and treatments can be. Roger believes he should have the freedom to say how much suffering is too much in his final days, so he decided to take action. On October 24th, 2016, Compassion and Choices filed Kegler et al., Heatley et al. In Massachusetts State Court on behalf of Dr. Kegler and Dr. Alan Steinbach, a physician who would be willing to write prescriptions for medical aid in dying but fears prosecution, seeking a judicial declaration that medical aid in dying is not criminal in Massachusetts because there is no criminal statute barring the practice. On December 31st, 2019, the court dismissed the case but did rule in our favor. Our favor. I don't know who wrote this. And one of the 6 counts in the lawsuit, physicians are free to advise terminally ill patients about this end of life care option to peacefully end unbearable suffering. Compassionate Choices appealed the court's decision and all other counts in May of 2021 and is currently awaiting a decision. Now, the Massachusetts Supreme Court had already denied his right to die, but in light of the Dobbs decision, which I don't know if you guys remember, the Dobbs decision was the case which um, am I okay? The Dobbs decision was the case in which the U.S. Supreme Court ruled that states could basically put limitations on the right to abortion. That basically there was no a right to abortion under common law, and that states had an interest in protecting the right to life. So that's the question. If it's a right to life, then whose right is it? Is it your right or is it the state's right? Because if you have a right to die, then I mean, if you have a right to an abortion, it's your life. Um, I don't understand whose right are they protecting because it seems to be paradoxical that they're protecting your right, but they're also not allowing you the discretion to exercise or decide how you want to live your life or how you want to die. You can't have a right to life without a right to die. So, and I know there's not anybody here right now. I don't really care. You can catch the replay later. I'm going to go ahead and get started and play the video.
SJC 13194, Robert M. Kliegler and another, v. Attorney General and another.
Okay, Attorney Capos.
Thank you, Ms. Chief Justice. Good morning, Your Honors. May it please the court. My client, Dr. Roger Kliegler, spent 32 years of his career as a physician helping to treat the citizens of the Commonwealth. Now Dr. Kliegler is asking the Commonwealth to help him. Dr. Kliegler has stage 4 prostate cancer, the most advanced stage. He wanted to be here today, but his cancer has spread and he is immunocompromised and unable to attend in person, but he is attending remotely. Dr. Kligler faces the very real prospect that he will experience an unbearably painful death when he reaches the final days of his illness. Dr. Kligler therefore wants a prescription for a medical aid in dying drug that will allow him to peacefully and painlessly pass if his suffering becomes overwhelming. Mind you, Dr. Kligler does not want to die. In fact, he has done everything medically possible to extend the time that he will have with his grandchildren and family.
I don't understand why it was necessary for him to say that, right? I think through. I mean, I watched this the other day, and I felt like he was playing it really safe. So he had to emphasize the fact that his client does not want to die. Okay, what about those of us who do want to die? Why? I don't even understand why it was necessary for him to say that, because he's trying to act in an abundance of caution, because he doesn't want to make this to be about I don't know, changing the law for those of us who do want to die. And so I think that he really undercut his ability to be an effective advocate for his client, because he played it entirely too safe. And yeah, like, what is he actually arguing for? If he doesn't want to die, then what is this case really about?
But he realizes that his illness will overcome him eventually, and he does not want to be forced to endure unbearable suffering.
If I could ask you about count one on the declaratory judgment, why aren't you asking really for an advisory opinion here? We don't have a prosecution. We don't have the prospect of a prosecution. And when we look at particularly involuntary manslaughter with the need to really get into the facts, the specificity, it's really concerning to think about an advisory opinion in this context.
So just to explain, there has to be a case or controversy in order for a court to have jurisdiction. There can't be an advisory opinion. You can't just file a lawsuit in order to get the court to declare the law unless you actually have a justiciable issue. So in order to get a declaratory judgment or injunctive relief, there has to be a continuous and irreparable injury for which legal damages would not be sufficient, because the preferred remedy in civil cases are money damages. But if money cannot adequately compensate you for your injury, then you can request declaratory or injunctive relief. So what they're saying is there is no controversy, or they're basically making a ripeness uh, issue or a question, that no one's being prosecuted, even though they potentially face prosecution, because that is the law that is on the book. They're saying that there is no justiciable issue. So therefore, it's I mean, I feel like this is an issue that should have been addressed at the district court level. I mean, I don't know why they're raising this issue at the Supreme Court. Like, it is. I mean, that's not even something that was raised at the district court level. So, the bottom line is that the doctor cannot prescribe medication to terminate his patient's life, because he would face criminal prosecution. So that is a continuous and irreparable injury, which monetary damages cannot compensate him for. So, no, I mean, it's right, because it's affecting the doctor's ability to perform his duty or make medical discretion in how he wants to treat his patients.
Thank you, Justice Lowy. We don't believe that this is an advisory opinion. Dr. Kligler, he has a very real illness. His cancer has progressed to stage 4. It's metastasized. He wants to live much longer, but he doesn't know how much time he's going to have. And this is an issue that if we were to wait until he were within 6 months of dying, we wouldn't be able to bring the case and get it through the trial court and through the appellate process before the plaintiff would pass away. So we really don't see this as an advisory opinion. We see.
Do you see how callous they are? Like, this is someone who is facing stage 4 cancer, who's going to experience excruciating pain, and they're basically saying you need to wait until that point comes before we can make a decision. It's too late for that. This is something that should have been addressed a long time ago. It's supposed to be your life, yet you don't even have the right to die. So it's not your life. Even dogs have the right to die. So why do dogs have a right that human beings don't have?
This is something that is capable of repetition.
But the prosecution would be of a physician.
That's correct. The prosecution would be of the physician.
And that's the advisory opinion that you'd be seeking.
But the
Situation, the plaintiff.
This court has noted in the Commonwealth versus Baird case that the choice to openly challenge a criminal law is unnecessary. It's unnecessary that you violate the law first, right?
But the doctor was a plaintiff in the original complaint. The doctor is a party to this lawsuit. So it says et al. Well, okay, maybe the doctor is not a part of this appeal, but the doctor was a part of the original lawsuit. So the doctor has standing as well as the patient. I'm not sure where they're going with this.
It would, if you think about this situation, no doctor would want to make the prescription and risk criminal prosecution and loss of their medical license. So this is a situation.
You shouldn't need a license in the first place. This is the problem. Once you bring the government into the picture, then they get to call the shots. So they get to say who gets to live and who gets to die, all because of that license. People think that it's no big deal that the government has the ability to license someone's livelihood, but it has real life ramifications. Now, someone who has stage 4 cancer is going to be forced to suffer or lose his livelihood because the government controls the shots.
And where if the court were to rule that there actually has to be a doctor that writes the prescription and gets indicted, I fear that it would never happen, and it would frustrate the process of having court review, because no doctor would ever be willing to risk criminal prosecution and their medical license in that way that we're talking about.
What is the closest legal authority you have for that proposition?
The Commonwealth versus Baird case was one case that dealt with that, and that's the one that comes to mind off the top of my head.
Thank you.
Can I ask you, I'm sorry, you done, Justice Swingman?
I am, thank you.
Can I ask you about a common law of manslaughter and where this fits in? We're discussing involuntary manslaughter, which involves intentional conduct by act or omission where there's a duty to act involving a high degree of substantial harm. And we're looking at, of course, Catalina and Carrillo, their heroin overdose cases, Wolanski, the nightclub, Coconut Grove fire, also the warehouse fire in Worcester. So we have that.
I take exception with the use of the word harm because they assume that by terminating someone's life that that person is being harmed. No, they're actually harming the person by forcing that person to suffer against their will. So even when it comes to the health and safety codes, when they use the health and safety codes as a backdoor to criminalize self deletion, they're saying that you're going to harm yourself. No, you're not harming yourself. I feel that I'm harming myself every day that I get up and wake. I don't, I mean, I don't necessarily want to make this about me, but there's a lot of people who are harming themselves by existing in a perpetual state of misery. So it's not harming yourself. I mean, that's so arbitrary. Like, I would object to that. I mean, what do you mean that the patient would be harmed? This is the patient's will. The patient wants to die. So you're not respecting the patient's rights to decide how they want to die. So you're the one who's harming the patient.
That line of cases where there's either they did something or failed to do something that caused great harm. Here, as I read your brief, you challenge two parts, and you go through the elements of common law manslaughter, and you challenge two of the elements. The first is causation, arguing that the patient caused her own death, correct? Not the physician.
So that's the difference between physician-assisted suicide and euthanasia. And euthanasia, which is what Dr. Kevorkian did, that the doctor actually terminated the patient's life within. Whereas in the case of physician-assisted suicide, the doctor prescribes the medication. So they're saying that when a doctor prescribes the medication, there is no causation for manslaughter because it is the patient who actually terminated his or her own life.
And secondly, the wanton and reckless, because there's a factual issue, you allege, as to whether or not prescribing these meds is a harmful consequence. It's actually a helpful consequence, and that's what the Attorney General says is, well, you're reading in a good faith exception. So turning to our case law, and forgive me for the hypothetical, but I'm going to have to give you one on the Pasampieri case, 1961 case. In Pasampieri, the horrible husband, abusive relationships, gives her the gun and she kills herself. If we flip that around, and we said that was manslaughter, if we flip the facts of Pasampieri around, and not to belittle Dr. Klinger's condition by any stretch, but I just want to use this for educational purposes. If we flip Pasampieri around, and rather than being a horrible person, he's actually a loving husband, and she has a critical disease, she's on her last days, and he says, I'll load the gun for you, here's how you do it, I'm going to walk away, we had a great life, and he leaves. How do we not have the same liability in Pasampieri that you're asking about in this case under our common law with causation and harm?
The problem with that counterfactual example is that it's the state that is putting that husband in that position in the first place. Nobody wants to blow out their own brains. The only reason that people do that is because they're relegated to that as their only choice. Anyone would prefer a painless death. Having to terminate your own life is traumatizing on a psychological level. It's cruel to put that person in that position in the first place. So if that person had the option of physician assistance, that would have never happened. So when you have people jumping off of a 20-story building or blowing out their own brains, that's the government's fault. They're creating the problem, but they're also creating the solution, right? We're going to put you in that situation where you have to terminate your own life, but then we're going to make it harder for you to do that. And then we're going to blame it on you. Like this makes absolutely no sense. Now, let's listen to the attorney's response.
Thank you, Justice Gaziano. That it seems like a very different case to us. We're talking about a compassionate option for
We have
peacefully.
a compassionate husband who doesn't want to see his wife suffer anymore.
Again, he's playing it safe, right? It's compassionate in both scenarios. The former scenario is more gory, but it's still compassionate.
Yeah, but gun violence we would never advocate for, and we would never condone that type of process. Medical aid in dying is a compassionate, peaceful way
Yeah, well,
for
that
Dr.
brings me
Kligler.
to,
But let me ask you, is there a good faith exception to this then? To the harm? As I see, what we read harm is harm physical harm or death, or is harm kind of, a bad faith exercise in this?
Yeah, I don't think we're arguing for a good faith exception necessarily, but what we see is that there is a very different causation element here where a doctor writes a prescription and then it is left to the patient and their own volition on whether or not they ever want to fill it.
He's not answering the question. The scenario that the justice gave him is analogous. If you give someone a loaded gun, it's the same thing as giving someone a prescription for I don't know, for something to terminate their own life. He's dodging the issue. I don't understand why he's doing that. Well, I do know why. Because first of all, he's not disinterested. He's worried about his own reputation. Um he's worried about how it's going to make him look. And I think that he really this served his client. I don't. I mean, just call it what it is. Just call it what it is. You're trying to make a distinction between, and it's not. There's no distinction. I mean, I wish I could have argued this. I actually wanted to file an amicus curiae, which is a friend of the court brief, and then even if you're not a party, you can interject and you can actually argue. There was an amicus curiae in here. I don't know if I'm going to get through this entire video, but um, I think I could have made stronger or more compelling arguments than this attorney.
Or ever want to
Okay,
self-ingest.
that's this situation. If we adopt your argument, do we open the door for the Pisampieri good husband situation I just laid out for you?
Well, the Pisampieri case, as I recall the facts in that case, the husband was actually present at the time and assisted the wife in loading the gun and in giving her instructions on how to kill herself. That is not what's going on here. This is a situation where the doctor gives the patient a prescription with the intent that the patient is going to have peace of mind from that and know that they have an alternative if their suffering becomes unbearable.
And death is reasonably foreseeable from the prescription, correct?
Not for any one patient. It is foreseeable that a significant number.
I don't know why he's not answering the question. There's two types of causation. There's proximate cause and there's actual cause. So under a but-for causation analysis, the doctor would be liable in both. Whether, I mean, it's the same thing. I mean, it's the same thing as giving someone a loaded gun. I don't know why he's. I mean, I guess because there is such a bias against death, people have such a anti-mortalist bias. So he doesn't want to say that. Prescribing someone I don't know, a pill that's going to terminate their life, that sounds more humane than someone blowing their own brains out. So he doesn't want to sound like he's in that same camp. But it's the same thing. Like, gosh, like stop being so emotional and just advocate for your client.
Of patients may take it, but for any one patient that we're talking about, you can't tell whether that patient is going to be one who never fills the prescription or fills it but never self-ingests. The statistics from the states that are allowing medical aid in dying currently show that over 30% of people who get a medical aid in dying prescription never end up filling it. So I don't think you can necessarily say that it is foreseeable as to any individual patient what the outcome is going to be in that case.
If over 30%, 70% of people were driving in a manner that led to an involuntary manslaughter instruction, we wouldn't say there was a causation problem. Or 70% of the time when the doors were locked in a nightclub and people couldn't get out and there was a fire and they died, we wouldn't say that there was a causation problem. It seems like that's a pretty high number for causation purposes.
Right, the language is high degree of substantial harm.
Right.
There are a significant number.
See, the problem is that he let that slide in the first place. When he raised the issue of harm, he should have objected or made some type of counter that we're not harming the patient. But he just let it slide. You're not harming someone who wants to die, and this you're acting in furtherance of their wishes. You're harming that person by forcing the person to live against their will. But he let that one go, and now it's becoming an issue because now he's backed into a corner. This is not a good position. Like, the best defense is a good offense.
I'm not arguing that there aren't. It is over 60% that end up taking it. But the considerations here are you've got people that are very close to passing already. Usually the people who are eligible and who actually self-ingest the medication are within days or weeks of dying, which is a situation where the harm from that is much diminished, we would argue. It's sort of, there's an attenuated state interest at that point when you get that close to death. And so the harm we would submit is much diminished at that point. And in connection with the the break in the lack of a break in the chain of self-causation
So
from the
you're,
point.
you're asking us to do this under the common law, and then you posit competency, correct?
That is one of the standards of care, correct? That
Okay.
the patient has to be an adult, they have to be competent,
And
they have to
is it
request.
6 months?
That's correct.
All right, what about 9 months or 3 months?
That has not been the standard that's been adopted, and I think the reason for that, Justice Gaziano, is that the 6-month cutoff is something that is well recognized right now already in the medical community and in the Commonwealth for other.
I mean, I think a threshold issue before we even get to this point is who owns your life, right? That is when you file an appeal that you can pose the question, right, of the answer that you want the court to address. Um, I would have posed that as a question. Who owns this? Who owns my client's life? Does he own his life or does the state own his life? And once they answer, he owns his own life. Because of course they're going to say that. They don't want to admit that he's a slave. Then I mean, again, he's playing from a defense instead of playing from an offense. Like the bias for pro-life is so ubiquitous that you can't you can't be on a defense when you're making these type of arguments. You need to be on the offense. You need to make them the villain. Make them they're the ones who are forcing this patient to suffer. They're the ones who's going to force him to die an excruciating death. And I mean, and the the problem is that he's probably making a whole lot of money for this. Um, I don't think that I would win because here's the thing: these cases are they're already deciding this, right? When you file your brief, they already know how they're going to rule. I have argued cases, which I'm not going to get into the details of it, but um, the judge was interested because the case was interesting. It was a novel case, so he wanted to have a hearing so that he could have oral arguments. He wanted to hear the debate, but he had already decided how he was going to rule. So this is a superfluous exercise. Like they already know how they're going to rule. I mean, and nobody's even going to see this, right? I looked at the views of the original hearing because it's on YouTube. It has very few views, and very few people have even heard of this case. So I don't even understand why they don't have to have oral arguments, by the way. They can decide and rule based on the appellate brief. But they wanted to have a hearing to make some kind of spectacle out of it. And they basically were giving him a chance to convince them to go against the precedent that is on the books. And I don't think he did a very good job.
Other end-of-life options like hospice, palliative care, voluntarily stopping eating and drinking, which, by the way, I'll just in connection with your
Well,
earlier
what if
question.
a physician, if a physician doesn't get two forms of, 2 forms of verification, or a physician does it 3 months rather than 6 months away,
That
would the
would be-
physician be liable?
No, not at all, because once you're within 6 months, it doesn't mean it has to be right at 6 months. It could be less than that. If the physician is
All right,
not
9
comfortable,
months.
That's not the standard that has been
Okay,
adopted.
would the physician who gives a prescription at 9 months, have they committed involuntary manslaughter?
They would be outside the protection of what we would consider to be acceptable standard of care prescribing. So they would be liable if they were.
8-month physician would be guilty of involuntary manslaughter too?
Yeah, although I'll preface that, but I would agree with you, Justice Gaziano, but I'll preface
The
that.
point is, it seems a lot like legislating to me.
Well, the legislature has not spoken one way or the other on this.
Well,
They've
no,
not-
no,
That's
no,
the
no, no.
problem.
It has spoken, hasn't it?
They've not.
They've
not
rejected the similar bill 5 times, I think.
There has been a number of bills that have come up, but they haven't chosen to enact any statute that
Right.
would
Isn't
make
that-
medical aid in dying illegal.
Can't we conclude that that's a rejection of those bills? The bills were very similar to yours. Also, the ballot question was similar to yours.
So just to be clear, there is no actual statute criminalizing physician-assisted suicide. It's just that it would be prosecuted as a manslaughter. So I don't think that this is the appropriate venue to bring this type of case because there is no actual law. Like Texas, we actually have a law in the books that says physician assisted suicide is a criminal act. So um I don't know that attorneys engage in forum shopping. They decide where they want to bring a case in order to change the law, and I don't think that this was the best venue.
And that did not pass.
There was a ballot initiative, and you are correct, Justice Cipher, that did not pass. There are ongoing bills in the legislature as well, though, so I don't think we can necessarily conclude that because the legislature didn't pass the bill the last time, it won't at some point in the future. But let me just say this, that this is a matter that arises under the common law of involuntary manslaughter. And so this court is best positioned to clarify what the law is on involuntary manslaughter and whether or not it would cover.
So you want us to write an opinion that says
Well, here's the thing, because I know you guys aren't going to be here for the entire thing, and I'm not sure that I'm going to get through the entire case, but Dr. Kevorkian actually jumped the gun. Like, Dr. Kevorkian actually terminated his patient's life and dared the state to prosecute him. And they wouldn't do it. So it really is going to take a doctor who has, I mean, he did lose his medical license, right? That's the problem. Most people don't want to lose their medical license, so they're not going to do it. Dr. Kevorkian is an American hero. I don't think people really understand the impact that he left. I think I don't know. People just act like it. I don't know. I mean, I know it was long ago because he died like in the 2000s or so, whatever. But yeah, there's probably not going to be another Dr. Kevorkian.
6 months is fine, but 7 months isn't under our common law of manslaughter?
I'm not asking the court to make that kind of a factual finding. I think what the court's opinion would be is that if a physician is following a medical standard of care, that it would be okay to do this. And the 6 month is a requirement that is written into the medical standards of care virtually uniformly in the 10 jurisdictions that currently permit medical aid in dying.
And
So-
can I ask you about those 10 jurisdictions? Do they do so under their common law, or has there been some legislative action?
There has been legislative action. I believe that Montana was under judicial pronouncement, so that was under common law. The other 9 jurisdictions have done so under legislation.
And that legislation prescribes that medical standard of care at 6 months?
That's my understanding,
Now,
correct, Justice
I
Bud?
thought the Baxter case, you're referring to the Baxter case in Montana?
Correct.
I thought that was an interpretation of a statute as it relates, as opposed to common law.
You're correct, Justice George, as that was interpretation of a statute. It was a carve-out. It was an exception to the manslaughter statute in Montana for someone who requests or a victim who requests a certain treatment.
Okay. Counsel, I'd like to focus for a second on, you talk about the issue of the constitutional right or the fundamental right to, what exactly are you saying? A fundamental right to die or a fundamental right to have a physician assist you if you're already going to die?
So just to clarify, the Constitution under the Due Process Clause protects the right to life, liberty, and property. So in order to have standing, you have to identify a specific liberty interest or property interest. But this is something that should have already been addressed in his appellate brief. I'm not sure why they're asking. I mean, again, this is really rhetorical. This is a dog and pony show. They have already decided how they're going to rule, but this is a spectacle. I mean, it's really entertainment or whatever. It gives them something to do. I don't know, or maybe it gives the public an arena to participate in this, to sit down and feel like they're a part of it. But they've already made their decisions.
It would be a fundamental right to direct one's medical treatment, and we view this as flowing.
Again, he's playing it safe. I would have argued that it's a right to die. I would have argued that by not allowing this patient the right to die, that the state is taking his life by without due process of law. But he wants to make it about a right to make medical decisions. No, um, the state does have a right to intervene when it comes to medical decisions because the state is the one that is giving um, or issuing medical licenses. So, guys, I would not have made these arguments, but then again, I'm not an attorney. They probably would not want to hear the type of arguments I would make.
Justice Cipher from the line of cases starting with Sakowitz and then Brophy and then more recently the Moe case.
Okay,
But all
and
those cases,
is that grounded in privacy or in liberty?
my recollection from those cases is it was grounded in both privacy and liberty.
Okay, so
So, I mean, again, I don't know. For those of you who have been on my channel, I've talked to y'all before that there are enumerated rights and there are penumbras. These are not enumerated rights, but these are rights that are necessary for the exercise of the enumerated rights. So, the right to privacy is not in the Constitution, but it is a penumbra. It emanates from certain rights, like the right to freedom of speech, the right to privacy, or the right to from the protection from unreasonable searches and seizures under the Fourth Amendment and due process. So there is no right to privacy, but I told y'all before about Justice Brandeis articulating the right to privacy as well as the right to be let alone. The right to privacy is really how we got the right to abortion as well as the right to, there's no right to sodomy, but there's a privacy interest and consensual sexual conduct. So that's where we got Lawrence v. Texas, where they overturned the Texas sodomy statute. So it's all based on a right to privacy.
So now, but why would we make a distinction between, we can't say that your physician has a right to prescribe and that this particular patient has a right to take his life before the natural course ends his life, without first concluding that we all have a right to die when we choose, correct?
I think the right that we're talking about is the right to direct one's own medical care.
See, she's trying to help him because she knows that that is a more compelling argument, but he's trying to play it safe. I don't know why he's doing this. And I mean, I'm sure she would have been a dissenting opinion. She would have issued a dissenting opinion anyway. But I think that if he would have made that argument, he probably could have convinced her to go along with him. But because a lot of times dissenting opinions, people will cite that, and then in a future case, that will become the law. So if he could have made that argument and convinced her, that could have become the law somewhere down the line. But no, he wants to play it safe.
I understand that, but underneath that right to direct one's own medical care, which the courts have distinguished there is a distinction between affirmatively giving somebody something to cause death and just a person choosing medical care, like I want this end-of-life treatment, I don't want that. But underneath that, there has to be some kind of right to for the patient to end his or her own life. I want to know, why does it have to be tied to medical care?
We would agree with you that the line of cases started out with drawing this distinction between refusal of medical care versus acceptance, but then Brophy advanced that to the point where it covered acceptance, and then Moe made it even more clear. That the Moe case, Your Honor will recall, was a case dealing with Medicare funding for reproductive rights, and that case very clearly made it apparent that the right to receive.
I want y'all to take note of the fact that he's referring to his notes instead of just answering the question off the cuff, because when you take the bar exam, you don't get to refer to notes. So this is why I say that the bar exam has absolutely nothing to do with the practice of law, where they stick you into a dark room and you're supposed to answer questions under time conditions without the benefit of being able to refer to notes. So it's not realistic. I think he should have just answered the question without referring to case law because she was willing to go along with it. That's what it sounds like to me. She would have been willing to consider a right to die that wasn't attached to a right to determine one's medical decisions.
Medical treatment, not only to reject medical treatment, was a fundamental liberty and privacy right. And so our view.
That's not the thrust of the liberty and privacy analysis in Moe. The liberty and privacy analysis in Moe has to do with what's viewed under the Constitution from penumbra as a medically necessary procedure, and the state not being able to compel women to have to give birth. It's a completely different situation than a physician initiating causation.
Well, it's analogous to the extent that the state is forcing people to live against their will, but he's never going to make that argument.
Well, the physician, Justice Lowy, does not initiate causation in this situation of medical aid in dying. It's the patient who requests it. This is not something.
First step. I mean, I understand that you have to go get the prescription filled and take it. But the first step in the causation links is the physician writing out a prescription.
Justice Lowy, we would disagree with that to the extent that the first step is the patient requesting it. Physicians do not.
How can you make that argument in the face of Catalina and Carrillo?
Well, first of all, let me just stress that Catalina and Carrillo, we're talking about cases where you've got drug dealers that are pushing heroin for personal gain.
You argue there's no causation because the patient causes her own death, correct? Because they're the one that put the pills in their mouth, right?
That is correct, Justice Gaziano.
In Catalina and Carrillo, we've said, and again, I don't want to demean Mr. Klinger, Dr. Klinger's condition, but in Carrillo and Catalina on causation, we said the fact that the person who dies injects him herself doesn't mean there's no causation for the person who supplies the lethal substance, correct?
Yes, there is language in the context of a heroin pusher. I would submit to the court, but you're correct, Justice Gaziano.
But don't look at the causation as to who does what. What's the difference here in the who does what?
The drug pusher is trying to profit, make money off of selling drugs.
Again, he's evading the issue. I told y'all there's a difference between actual causation and proximate causation. So I don't know why he's trying to dodge the issue. The doctor is the cause of the patient's death. I think he should just admit that and move on. But I mean, you only get so much time to present these or your arguments, but they're getting hung up on these side issues because he won't just call it for what it is.
That's not, you're ducking the question. Answer the who does what on causation, without the dramatics.
The who does what? It's the heroin dealer who is selling the drug.
Right, so the heroin dealer supplies the lethal substance. The user injects him or herself, and they die, right? It's the injection that causes the injection. So what you're saying is the patient causes his own death because they put the pill in the mouth. How is that different from the addict? Again, different situation, but how is that different from the addict who puts the needle in his or her arm?
Well, didn't Carrillo result in actually an acquittal?
Yeah, because of the lethality of this. That doesn't help you, because Carrillo dealt with the lethality of the heroin as to whether or not it was laced with fentanyl or whether it was regular old heroin. That doesn't help you at all.
So the doctor, in the case of medical aid in dying, at the patient's request, does provide a prescription, and we don't disagree with you that in a significant number of cases, the patient will self-ingest and pass away when their condition becomes very near end stage. That does happen in over 60% of the cases, the data shows. We submit, though, that The intent is different. The doctor is not present at the.
None of that is relevant, right? Okay, it's relevant to the extent that you need intent for manslaughter. But no, not necessarily. You can have involuntary manslaughter. It's still, I mean, the intent is only relevant as to what type of manslaughter they're going to charge him with. But you can still have involuntary manslaughter. So um, the causation is the same in both cases. I'm not. This is, I mean, this is an attorney that somebody's paying a lot of money for. I mean, gosh, man, I think I could have done a much better job. I mean, I don't think that they necessarily would have bought my arguments, but I would have at least put them in a position where they would have to admit that they're forcing this patient to suffer and die, or suffer a slow, painful death. And I mean, what he's doing right now is bullshit.
The time that happens, I think in a lot of these heroin
I'm just
cases.
focused on, I know the intent is way different.
Yeah.
I'm just focused on the causation element. And I don't see how you can make your argument in the face of Catalina and Carrillo.
Well, we submit that the self-causation, the chain of self-causation is not broken by the doctor intervening. And I realize that there are, in the context of these heroin cases, there is authority from this court that has recognized an element of causation in situations dealing with heroin. We think that this is a very different fact pattern, but if we want to focus only on the causation element, Your Honor is correct that there is a similarity there.
Can we talk about intent for a moment? You just mentioned intent. And
I don't know if y'all saw that, but his co-counsel just passed some notes. Again, this would never happen on a bar exam. So the bar exam is completely unrealistic. You don't get to pass notes to people.
the intentions of the physician are sublime, and I'm sure they only have the best interest of the patient at heart. And whether or not this is an important and a good idea legislatively is an entirely different issue. But don't you have a problem here where with involuntary manslaughter, the intent we're talking about is the intent to do the act, not the intent to cause the death?
I do understand this court's precedents, Justice Lowy, to focus on the intent to do the act, and that is correct that the doctor does write the prescription, and so.
Right. So there's transferred intent. You have to have intent to give the drug, and whether you're a drug dealer or you're a doctor. And so if the drug causes a person to die, it would be the same. I don't know what he's doing right here. This is some mumbo jumbo. Like it is the exact same thing. Yeah, I can't make any distinction between the two. Like I don't know. I mean, I don't want to get too deep into that, but transferred intent, the intent is for the initial act. That's what you would be charging them for. That you intended to give that drug. And so if it causes the person to die, then the intent would transfer to the actual death to make the charge a manslaughter.
That's not necessarily a distinction, but we do feel that the intent to help the patient rather than to profit from a drug deal or to kill one's wife in the case of Piacenpieri is a rather different element.
It's dramatically different, but we're analyzing the elements of a common law crime, not whether or not the legislature should take that difference into account.
Okay, y'all, I'm going to break this up because this is an hour and 11-minute video, and I'm not going to cover the entire thing. What I'm going to do is I'm going to break it up. I'm going to finish his arguments because he's almost done. Then I'm going to get to the attorney general, and then I'm going to get to the amicus argument. So we're about to wrap up. and then I'm going to come back and finish this up and do a part 2 and a part 3.
I'm sorry, I didn't understand the
So,
question.
so I understand the difference. It's a huge difference. And again, at the risk of redundancy, this might be a very important, a good idea as a public policy matter. But when we're talking about a common law crime, we're dealing with intent that's developed through the years, and it's not the intent to cause the death. It's the intent to do the act.
Yeah,
The act of giving the prescription.
right. And there is, we don't disagree with you on that, Justice Lowy and Justice Cipher, that the doctor, at the patient's request, does give them a prescription and intends to do so. I want to point out one other thing, and that is we haven't really talked about the court's decisions in the 2 Carter cases. And I know there was some language in Carter 1 to the effect that this court actually pointed out that case, that was the case where the girlfriend pressured her boyfriend into committing suicide and to get back into the truck that was gas infused. And this court noted that this is not about a person offering support, comfort, and even assistance
Well, and
to
you
a
know what
mature
happened in
adult.
Carter too, right?
I do, yes.
Assistance was no longer in the opinion.
Yes, but there was a lot of language about the lack of a break in the chain of self-causation in that case, right? In this situation where this court said that had the young man remained in the gas-infused truck and died at the insistence of his girlfriend, she would not have been criminally liable. It was only when he got out of the truck that broke the chain of self-causation. And then she compelled and pressured him to get back.
This is absolutely terrible. I mean, he's wasting all this time with these frivolous, nonsensical arguments. It's hard to say that it's the court's fault I know I put the title that the court callously denied him the right to die, but I think the attorney actually screwed his own client over. Like, these are some really shitty arguments.
Back in the truck, that there was criminal liability. And so if we apply that to our situation, there is no break in the chain of self-causation from the point that the patient fills their prescription.
I understand, counsel, that it depends on where you look at this in terms of how you have analysis. It was the causation when the prescription's written, is it started when the patient asks? But you have a case where a doctor could write the prescription and perhaps the patient fills it.
Okay, if you think these people are fascists, wait until you hear the attorney general, because the attorney general and the amicus appearance, it gets even worse. This is supposed to be this is supposed to be attorney who's advocating on behalf of the patient, and he's doing a very shitty job. But when you hear the attorney general, man, it's going to blow your mind away.
It but doesn't take it, and now the substance is out in the world. Isn't there some kind of danger we have to be concerned about with that?
That's not been borne out. I understand your Honor's concern, Justice Cipher, and it's a good point, but we haven't had that problem in the thousands of cases that have been, where this has been used in other states. People are
One other
generally.
question, I actually have a couple, but one is, what's the difference between involuntary manslaughter in this case and second-degree murder, third-prong malice? 'Cause it's a very small, slender difference, really.
Yeah, I don't.
I'm just curious whether, even if we did this, would there not be a potential charge of second-degree murder on third-prong malice?
I don't know the elements of
Okay.
that, so I can't speak to that,
All right, and
Your
then,
Honor.
can I take you for a minute to the constitutional arguments? You're talking about this needs strict scrutiny analysis, is that correct?
Yes.
But we don't even get there, do we, unless we're in equal protection? Could this not be resolved as a fundamental right and under ordered liberty?
Just to give you a quick overview, there's 3 levels of scrutiny. There's rational basis, intermediate, and then strict scrutiny. And the goal is to get strict scrutiny because Strict scrutiny means that any type of government regulation has to be narrowly tailored to achieve a compelling state interest. So there's two barriers to that. And then rational basis means that the government regulation has to be rationally related to a state interest. So it's a very low bar when it comes to rational basis. I'm not even going to address intermediate scrutiny, but you want to get rational. I mean, you want to get strict scrutiny. Strict scrutiny is going to apply to things that are fundamental rights, any type of race, gender, or no, not gender. Gender is intermediate. Religion is intermediate. Um, but a fundamental right. So they're talking about the equal protection clause. It has to be a fundamental right, and he's saying that the fundamental right here is the right to direct your own medical decisions. No, the fundamental right is the right to die, and he doesn't want to say that. So again, I think he screwed his own client over. And again, she's trying to help him, and she's telling him what he needs to say in order to get her to go over to his side, and he's still not saying it.
And
It-
just look at it that way?
It could be. We argue that this is a fundamental right, as we talked about earlier, and that if we're going to talk about equal protection, that a heightened level of scrutiny should apply. But we could.
The equal protection argument should be that human beings don't have the right to die, but dogs do. So how about that? How about the fact that dogs have more rights than human beings?
Analyze it under just liberty and privacy, and I think our briefing did that.
Okay, all right. Thank you.
Okay, looks like we're all set. Thank you.
Okay, I didn't realize that it was going to take me that long to get through this first part. So again, I'm going to break this up. I'm going to come back and do a part 2 and a part 3. I want y'all to listen to what the Attorney General had to say about this. And I want y'all to let this all sink in, that you don't actually own your life. The government owns you. You are not your sovereign. The government is the sovereign. You are a subject and a slave. If you don't have the right to die, then you really don't have any rights at all. So, yeah, I hope I'm making this clear that you're not nearly as free as you think you are. So worry about your own preservation. Stop worrying about some damn animals who have more rights than you, and fight for your rights. So I'm going to end this live stream, and hopefully I'll be back tomorrow. But thank you all for listening, and those of you who weren't here, let's check the